Hello and welcome, everyone. My name is Cooley. I'm the Director of Targeted Outreach at the California Department of Financial Protection and Innovation. Thank you for joining the webinar. I know it's right at noon, so let's give everyone let's say one more minute to join before we get started, okay? So one more minute, we'll get started very shortly. Thank you for joining. Okay, let's get started. Again, hello and welcome to the Financial Education webinar, everyone. My name is Cooley. I'm the Targeted Outreach Director for the California Department of Financial Protection and Innovation, also known as the FBI. Today's financial education webinar we are covering is about securing your legacy with estate planning. A lot of really great topics and sources of information, so let's get started right away. Just a little disclaimer here. Your cameras and microphones have been turned off for the duration of this webinar, but please submit your questions through Zoom's Q&A feature. The views and opinions expressed in this presentation are those of the presenter. They do not necessarily reflect the views or positions of the DFPI. This presentation is for educational and informational purposes only. This is not legal or financial advice. And does not replace any kind of independent or professional judgment or your own research. We're a big proponent of you going out to do your own research, and you're going to hear that a lot because this topic is a very high level overview of estate planning, and the reality is everyone's I want to say estate planning process, estate planning journey is going to be different because we all live different lives. And again, we want you to do your own research to make sure that you get the right information for that works for you. For more information, you could always email my team. We have an inbox which we all review and manage. The email address is outreach@dfpi.ca.gov. Okay. Just quickly to talk about the DFPI. Who are we? What is our role? What do we do? The DFPI's central purpose is to maintain a fair, healthy, and trusted financial marketplace for all Californians. We are California's financial regulator, and because of that, we do this through regulating and enforcing a variety of financial services, products, and professionals. We also provide free presentations all throughout California. We do this to help consumers from falling prey to fraud and scams. And of course, we do have a dedicated section on our website where we publish news articles, consumer alerts, a list of different events we do virtually and also in person. So please check out that link, that section of the website. The link is dfpi.ca.gov/consumers. All right, one more plug before I jump right into the topic. The DFPI offers free online financial education. All you need is to register with your email address, and then you'll get access to a number of different courses and modules, things such as budgeting, investing, retirement planning, paying for debt, getting out of debt, building credit. Also, estate planning is one of the modules that is available. The link to register for that free online financial education is dfpi.ca.gov/learn. All right, so let's talk about estate planning. It is a very complex And I want to say it can be a very confusing process. But you're here to learn, and thank you for joining. And let's go through some of it. Again, as a disclaimer, this is just a very high level overview of the estate planning process. Everyone's situation is going to be different. Maybe you just need a will, maybe a trust is what you need. Certain taxes may affect you, or you may have assets, or you may not have certain assets that we're going to talk about. But again, very high level overview. We highly encourage you to do more research on some of these topics. We're just going to we're going to hit on a couple of them, give you a brief overview, and then hopefully that'll give you enough information to get started and get learning about creating your estate plan, or even just updating your own estate plan. Okay, so what is estate planning? The estate planning is the process of determining what happens to everything that belongs to you, or that you're responsible for in the event of your incapacitation or death. And estate planning documents can include directions for many aspects of your life. And these are the 6 topics that we're going to be covering. Guardianship of your dependents, distribution of your assets, charitable giving, business transfers, and of course, healthcare directives. Oh, so last one, directions for your final arrangements. So these are all the different topics that are in estate planning, right? Again, talking about how you want your assets distributed, as well as if something happens to you, you're incapacitated, how do you want your wishes carried out, and of course, final arrangements. So why do you need estate planning? If a person passes or is incapacitated without an estate planning document or plan in place, the state or the government essentially will decide, through what how your assets will be distributed, right? Or sometimes they may even, if you don't have a designated person to carry out your wishes, especially if you're incapacitated, then and you don't have a next of kin to do anything, then you fall into the stewardship of the government, and that's not necessarily something you may or may not want to do. So, in probate, it's a legal process of distributing a deceased person's assets and properties to their heirs and beneficiaries and settling any kind of debt. For the most part, most people don't want to get into probate because it's a very long process. And we'll talk a little more about the probate process. If you've never had to go through this before, like, have a very close family member pass away and they only had a will, or maybe they had no will or trust or anything like that in place. You may not know what probate is, but again, we'll talk a little more about it. It is a legal process, and it's a way to protect everyone involved in that person's life, right? And we'll talk about some examples, and I'll share some stories too. So let's talk about some misconceptions about estate planning, right? An estate plan is only for the wealthy. That's a very common misconception, where people think, well, if I don't have a lot to give, or I don't have a lot of beneficiaries, I don't need an estate plan. But if you don't have an estate plan, then what happens is the government, a judge, essentially will decide how your assets will be distributed among any kind of beneficiaries you may have. And by the way, if you don't have any beneficiaries at all, what may happen is the value of your assets may be given to the government, as a what do you call it? Well, it may be given to the government, right? So another misconception is that I'm too young to need an estate plan. And that kind of makes sense. I've talked to very young adults when they ask about estate planning, and very oftentimes it just kind of goes over their head, right? And they're young, I get it. But as a working professional, I think, especially when you start building and collecting assets, it's important to have an estate plan in place, so that, again, your wishes can be carried out, and also that you don't have to, your beneficiaries don't have to go through a very expensive probate process, because probate can be very expensive. I already have a will, so my beneficiaries are protected. And that can be true to a degree, but you, depending on your beneficiaries, depending on what assets you might have, a will might be all you need, right? But we're going to talk a little bit about the difference between a will and a trust, and how you can protect your beneficiaries, as well as how your estate is distributed, and also even save you a lot of money for your beneficiaries, so they don't have to go through that probate process. I need to do this by myself. Another misconception, you don't have to, right? There are many professionals out there. I would definitely suggest that if you're looking for professionals, that you do your due diligence, right? Get quotes, learn about them, get testimonies, as well as check the reviews. But you don't need to do this by yourself. There are like do it yourself kits out there for wills and trusts and that kind of thing. And if you want to save money, that's a path you could take. But at the same time, if you would prefer, especially if you have a lot of assets, maybe you have a lot of beneficiaries, having a professional set it up for you might make sense, right? So explore that option. Once I sign the documents, I'm done. Again, another very common misconception. We'll talk about the importance of updating your will or your trust. And but yes, you definitely want to try to update it all the time, as time goes through, as life continues to change, right? So, and let's see, I only have one beneficiary, so I don't need a plan. Again, another misconception, especially if you only have one or very few beneficiaries, you think that maybe I don't need a will or a trust or any kind of estate planning process. And the problem is sometimes beneficiaries can't be found, or the other thing is that you still will need, depending on the size of your estate and your assets, you may still go through the probate process, which is a very long process. And especially if you don't have any life insurance in place, your beneficiaries may not be able to pay for your funeral or other arrangements if they don't have access to your accounts, right? Your bank accounts, your any kind of assets you might have, because it's stuck in probate. Okay, so let's talk about how an estate plan will help you. It will definitely reduce family conflict, right? Because it will tell how you want your assets distributed to your beneficiaries. It will minimize taxes and also fees that are associated with a probate process. It would reduce legal expenses. It'll definitely reduce legal headaches, right? It'll help preserve your wealth. Again, a lot of your wealth will not be going to a probate court to pay a probate judge or probate lawyers. Instead, that value, the wealth that you have, will be going directly to your beneficiaries. Again, protect your assets and provide for your loved ones. And it can, again, definitely help you carry out your final wishes. Okay, let's talk about the 4 documents that your estate plan should include, right? The first one is a will and a trust. Again, a will or a trust, and sometimes it can be a will and a trust, but it's essentially a document that kind of course, lists your assets as well as distributes, how you want your assets to your beneficiaries and other things. Very, very important. One of the very first documents you have, but you're not done there, because you're also going to want a power of attorney. And a power of attorney is essentially you granting someone the authority to either carry out your wishes, right? So in the trust, it's an executor, but essentially when you pass away, you want to give someone the power to, again, execute your will or trust. And it can also be a medical power of attorney, right? Essentially, if you become incapacitated, that power of attorney will give that person access to things like your bank accounts, as well as to make financial decisions, maybe even medical decisions on your behalf. And of course, we talking about that, we talk about advanced healthcare directives, or a living will. And again, that's more towards the medical side. If you become incapacitated, or no longer have the mental capacity to make financial or decisions on your own, you're essentially giving someone that directive or power of attorney to make those decisions for you. And then finally, you want a Health Insurance Portability and Accountability Act release, also known as a HIPAA release. And what is that? Basically, it's a federal thing. Basically, your medical information is protected, and a hospital, medical professionals, whoever, will not allow your medical information to be shared with others unless you have a signed release from you, giving access to those individuals, right? So it could be your children, it could be someone that you appoint as your healthcare directive, someone going to carry out your healthcare wishes. You want to make sure they have a healthcare HIPAA release so that they can actually look at your medical records and make those decisions for you. All right, here's some more legal terms. Again, I'm not gonna read through all this. It would take me all webinar, but I want to highlight some of the high level legal terms that you should get to know, especially when you start getting deeper into wills and trust, because many of these will talk about, what is a beneficiary, what is a fiduciary, executor, grants, power of attorneys, what is estate, what are assets, right? All these legal terms, again, very important for you to know, so that, again, when you're signing documents, when you're reading through documents, you understand what they are, who they are, and why they're doing certain things, right? Again, here's some more. The rest of the terms here: probate, trust, trustee, will, right? These slides, by the way, will be made available to you, to everyone who actually registered for this webinar. I'll be sending a follow-up email that has a copy of these slides, as well as a link to the webinar recording. So look out for that, and then you could go through these slides and read through them at your leisure. So let's talk about a will of trust, right? Going back to the 4 documents that your estate plan should include, let's talk about wills and trust. The difference between a will and a trust, right? So trust may take effect while the grantor or the person who created the trust is still alive. They do not go through probate and instead remain private. So all the information of a trust will stay private, right? So your information, your beneficiaries' information, everything remains private. It may have protections against certain taxation, litigation, or creditors, right? So if you owe a certain amount of money, they will not be able to, and you pass away, those creditors may not be able to touch your trust, because your trust is kind of a separate entity. Let's talk about wills. Wills take effect after the death or incapacitation of the testator, or basically you. They do not include instructions for your care in the event of incapacitation, and they typically go through the probate process and become or have are public. And the reason why the wills are public, the probate process is public, is because when you have a will and you pass away, the will gets given to, especially if the value of your estate exceeds a certain amount. We'll talk a little more about that. But if you have a very sizable estate, and lots of different assets, it will go to a judge. They'll review the will, but they'll also need to give the public, the general public, enough time to come in and make claims against your estate, right? So we're talking about creditors, right? If you've taken out outstanding loans and passed away, creditors are going to come back and say, hey, this person owes me money. They made promises. Maybe there are beneficiaries, which you forgot to add in, and they want to make a claim against your estate as well. So that's why the probate process is very long. It gives plenty of time to make claims, as well as it's public, so people know where to go and to get more information. And again, wills don't offer protection against certain taxation, because a will is more of just instructions, right, on how your assets should be distributed among beneficiaries, but it's not like a trust, which is kind of its own separate entity. You may want to avoid probate, right? you may want to avoid probate. Sometimes people want to go through probate, and there's nothing wrong with that. But probate can be expensive. There's a lot of legal fees, court costs, administration fees, appraisals. By the way, is if you have a lot of assets, you have to have it professionally appraised so that the courts, the judges, they can determine how much value your home, land, collections, all that kind of thing, besides your stocks, all that kind of financial assets. You probably have some real assets as well that you might have wanted to distribute, but there might not be a fair distribution among assets. And again, you have to get it appraised, right? And sometimes those appraisals come fast, and sometimes they could take a long time, especially if you have a lot of specific assets. I'm thinking more like car collections, right? It's a little bit more unique, but maybe you're restoring a car. You have a really nice classic car, and once you pass away, who gets it, right? Even though your will says you're leaving it to your nephew, um, maybe someone wants to make a claim against it. It has to get appraised to what is the value of this classic car that you restored. They have to find an expert to do the appraisal, that kind of thing. So again, just it can be very expensive, and it can take a long time as well. Again, talking about time, there are many steps like validating the will, inventorying, appraising again, notifying creditors. So if you have creditors, if loans, things like that you've taken out, paying any kind of debts and taxes you might owe, and of course the distribution of assets. So this is all part of the probate process. And a judge usually does this, and sometimes they'll appoint an executor to do this once those decisions have been made. Again, we talked about being a public process, right? It's a matter of public record, meaning that anyone can access information about the assets, debts, beneficiaries, again, as well as you. And they do that again so that everyone has that opportunity to make a claim against your estate, right? Maybe you made a handshake deal a long time ago, and you never paid that person back, and now they're coming and saying, "Hey, we made a handshake deal. This person owes me a certain amount of money," and so the judge has to take that into consideration. It can be complex and bureaucratic. I've heard nightmares about probate. I've had a couple of people come talk to me during resource fairs or presentations, and they'll say how long they've been in a probate, or that they lost a lot of money because the probate process was so long, right? I've heard probate processes going more than 10 years. And in that specific instance, there was land. So the person who passed away had land they owned, but it was out of state, right? It's not in California, it was out of state. So it was a very long process because you're dealing with multi-state laws about asset distributions. There's also the land had to be appraised. And so there's a lot. It was really, really long. And the family luckily had life insurance. So they had some kind of money which they could pay for the funeral costs. But they had to wait a really long process for like, again, 10 years for the probate process to resolve before they could finally get those assets. And very commonly, probate could lead to family disputes, right? Who gets what? And maybe, especially if a will was created really long time ago and it was never updated, you could have brothers arguing, saying, "Hey, Grandpa said that he was going to leave me his car, but then in the will it says the car goes to someone else." So yeah, could create a lot of tension in the family. And again, tie up assets, right? Talking about land, maybe your loved one that passed away has a lot of vacation homes. Those vacation homes are going to probably be empty if it's stuck in probate, right? You can't do anything, can't touch it, you can't access it until the probate process gets resolved, because technically no one owns it, right? The owner has passed away, and so now those assets go into the government's hands until the probate process can resolve, and then the keys to those vacation homes, the titles can be transferred to whoever the judge deems, right? Okay, talking more about avoiding probate, right? In California, And by the way, they update this almost every other year, but every year sometimes, every other year. So probate is required in California when personal property value exceeds $208,850, and that's if the person passed away on or after April 1st of this year, so 2025. And by the way, I've had people comment on webinars that I've done years ago. This is going to this is as of this moment, right? 2025, personal property value, right? There's that threshold, and personal property value again could be financial assets, stocks, bonds, bank accounts. It could be collections, right? So your friend's Pokemon $100,000 Pokemon card collection, that value again has to be assessed, and then and then that will be part of that property value, if probate if it needs to go in probate, right? Primary residence, right? If you have a house, if that person passed away, has a house, if the value is more than $750,000, probate will be required. And by the way, this is not about trust. We're going to talk about the next slide. This is if you have a will. If you don't have a will, all this, the probate process will be required. And other real estate value is more than $69,625. If you have someone you know or a part of their lives and they pass away, they don't have any personal property, they don't have any primary residence, and they don't have any other real estate, you may not need probate at all, right? So small estates under these thresholds can use simplified procedures 40 days after death, instead of that formal probate. So again, these are all kind of little thresholds that probate will be required if there's a will or if there's no will, and of course it meets these thresholds, right? And here's a link, right, for the source of all this information. You could read more. There's actually, it's a very long page and it's got a lot of information. I think it has a couple different examples so you could better understand it. So one of the things I get asked a lot is, hey, my grandpa had a house, it's worth $1 million, but there's a $500,000 loan, right? The mortgage is still $500,000 on it. Does it fall underneath this threshold, that kind of thing? No. It's $1 million home. It exceeds the value, regardless of what mortgage it might have on it. The value is $1 million, and if there's a will, if there's no will, it will have to go to probate because of that, right? So again, small states for these thresholds, read more. There's a lot of more information. I want you to do your research. Again, we just want to give you a high-level overview. So let's talk about how to bypass probate, right? If you have assets that are included in a living trust, again, that living trust is kind of its own separate entity. It will bypass the probate, right? That $1 million home, it's in a trust, so you don't need to worry about it. The trust will be executed, and however that home once get transferred, maybe it gets sold and the value gets distributed, right? All that will be in the trust. It won't be part of the probate process, if there is supposed to be a probate process, right? Joint tenancy property. So basically homes or accounts owned as joint tenants, with a right of survivorship. These types of assets are outside of the probate process. Financial accounts, right? Any financial accounts with a pay on death or transfer on death status, right? Those bypass probate. So let's just say your grandfather, he's in what do you call it? He's in a healthcare facility, and he decides to take all his financial accounts and mark them with a pay on death or transfer on death status, so that when he does pass away, the ownership of those financial assets, or maybe ownership would be the right word, it will go to a designated person. So maybe that person is the one who is carrying out the funeral arrangements, right? And they're going to need access to those bank accounts and money to pay for the funeral arrangements, right? These financial accounts, again, marked with pay on death or transfer that money on death, are outside of the probate process. Life insurance. retirement accounts with designated beneficiaries, those assets are outside of the probate process, right? This is why it's so important to have some kind of life insurance in place. Again, that life insurance money is supposed to help not only pay for funeral costs, but help individuals continue on without the burden of losing income, especially if they have to wait through wait for the probate process to settle. Any kind of retirement accounts, right? Maybe you have a IRA, maybe you have investment accounts. Those with designated beneficiaries will be outside of the probate process. Okay. If you don't have any designated beneficiaries, then again, it will have to wait. It'll be part of that probate process. The judge will decide how, especially if you don't have a will, how that money will be distributed to your loved ones or other people or other creditors who you might owe money to. And I'm gonna throw this in here. Sometimes vehicles, right? It's kind of a gray area. Some vehicles could bypass the probate. Again, depends on the value, depends on what kind of vehicle it is. Maybe it's a collector vehicle, right? 62 Chevelle might be considered a collectible asset, and that needs to be part of the probate process. If it is a 92 Honda that is on its deathbed, that might not be required as part of the probate, mostly because nobody would make claim to it, but also it's a small value asset, right? So again, I'm not an expert on this. All this information comes from, again, this link right here, the self-help courts, selfhelp.courts.ca.gov. Great link website to go to, learn more about probate, how to protect yourself, as well as how to stay out of probate, right? Let's talk about some professions that may want to keep their personal information away from probate, right? Again, remember, probate, when you're in probate, the information of your beneficiaries will need to be made public. And that's because, again, the process is a public process, and the judge, they are going to be distributing the assets to the individuals, and these individuals need to be known, right? Not just unknown parties, random names. No, it's going to be actual people with their information known. So if your beneficiaries are social workers, maybe they are law enforcement, judges, correction officers, attorneys, if they're teachers, psychiatrists, psychologists, maybe medical professionals, maybe if they're business owners, right? They want to keep their information private, and especially if they're public figures, right? So think about like celebrities. Maybe if they're public figures, again, they want to keep their information private. But if they're named in a probate, then if they want to claim that value of the probate, they have to allow their information to be made public for everyone to know. So consider that when you're thinking about creating a will or not having a will. Anyone who wants to make claim to your assets will definitely have to make their information public, which includes their occupation, which again might make them vulnerable. Okay, let's talk about trusts. I want to look at my time. I'm doing well. Okay. We're going to fly through some of these slides. There are two types of trust, right? We have a living trust that takes effect while the grantor, who's part of that living trust, is alive. This type of trust allows a trustee to manage your estate, make decisions on your behalf in the event you become incapacitated. A living trust can be revocable, which means it can be changed or canceled by the grantor at any time. If it's irrevocable, it means that the trust can't be changed or canceled during the grantor's lifetime, right? So again, separate entity, you give a trustee the ability to make changes, especially if it's make decisions on your behalf, we have that revocable or irrevocable trust, right? And then we have a testamentary trust, and that establishes a person's will and only takes effect upon the death of the grantor. This type of trust allows the grantor to create very specific terms for the transfer of assets to beneficiaries. The example is, if you're designating a specific age at which a minor will be able to receive the inheritance, or maybe specifying a specific monthly schedule for distribution of the assets to a beneficiary, right? So this is usually where you hear the term like a trust fund child, right? Someone passed away, left a lot of money to them, but they can't access it because of the terms of their testamentary trust. What if you become incapacitated, right? Well, a will not be able to help you here because a will only takes effect if you pass away. But in the event of a trust, right, you want to make sure that your financial plan includes directions for your care and the care of your dependents in the event of your incapacitation, right? So you want to include a durable power of attorney, which designates an individual to manage your financial affairs. You also want a healthcare proxy. So it designates an individual to make healthcare decisions on your behalf. And of course, a healthcare directive, which dictates which medical procedures, treatments, or healthcare decisions you've made for yourself, right? This document is left with your doctor and is sometimes called a living will or directive to physicians, right? So maybe you don't want to be operated on. You make that part of your healthcare directive. Okay, so we talked about wills and trusts. That was a big chunk of the presentation. Again, very high level overview. I skipped over a lot of stuff because, again, I don't have enough time to spend with you. Also, I'm not a specialist about wills and trusts. But again, a lot of the information I got from public sources, you go check out yourself. And again, everyone's own situation is going to be different. So a will or a trust, or maybe both, might apply to you or it might not, right? Let's talk about power attorneys. So power attorneys, again, it is one of the documents that you should have as part of your estate plan. So different types of power attorneys. We have your general power attorney, special or limited power attorney, your durable power attorneys, spring power attorneys, healthcare power, or also known as medical power attorney. By the way, again, for time's sake, I'm not going to read through all this, but I will fly through it. And again, these slides will be made available as well as a link to the recording, so you can always go back and watch it. I will say, if you do, as a reminder, if you do have any questions, please feel free to submit it into the Zoom's Q&A feature. I have a dedicated time at the very end to answer questions, and I could talk a little more about some of these power attorneys. There's always a lot of questions about it. Okay, so general power attorney grants broad authority. It includes things like managing your bank accounts, paying for bills, buying or selling property, making investments, filing taxes, that kind of thing. Generally, a general power attorney is non-durable, meaning it automatically terminates if you become incapacitated, right? So we have a special power attorney. This type of power attorney grants your agents very specific and limited authority to act only in certain situations, right? So examples include things like authorizing someone to sell a specific piece of real estate on your behalf, right? So maybe you have a real estate professional that you trust. You give them a special power attorney and tell them, hey, when I pass, you have the authority to sell or maybe you're incapacitated. You have the authority to sell this estate to pay for medical bills, maybe give the money to my beneficiaries, right? Granting someone power attorney, pick up a specific package for you, or access certain, maybe like a storage unit or something, right? Generally, these are non-durable, meaning it automatically terminates if you become incapacitated. And then best used for things like if you don't want to give broad authority, right? So again, you're getting very specific, limited authority for people to do things on your behalf. Now we have the durable power of attorney. The durable power of attorney specifically designed to remain effective even if you become incapacitated, right? So best used for things like, future incapacity. If you become incapacitated in the future, ensuring someone that you trust can manage your financial affairs if you are no longer able to. Spring power attorney, it's a type of power attorney only becomes effective upon the occurrence of a specific event or a condition, right? Most commonly for mental or physical incapacity, best used for situations where if you are hesitant to grant immediate authority, but want to make sure that someone can act on your behalf if you do become incapacitated, right? So maybe you have a spring power attorney because you have a specific medical condition and you want to give them that ability to make those decisions if something specifically happens within that medical condition. Healthcare power of attorney. This is where it deals specifically with your healthcare decisions, allows you to appoint an agent to make medical choices on your behalf. Um, the authority that your healthcare agent will have includes consent or refuse medical treatment for you. They'll be able to access your medical records. Again, make sure you have the HIPAA release there. Make decisions on your in-life care, right? And it's best for ensuring your healthcare wishes are respected and that someone you trust can make those medical decisions for you, especially if you cannot. Okay. All right. So we talked about wills, trusts, power attorneys. The next document that your real estate, so your estate plan should have is an advanced care healthcare directive or living will. So what is a living will? It's a legal document that outlines your specific instructions for medical treatment. If you become seriously ill or incapacitated, it is a crucial part of advanced care planning, right? Ensuring your wishes regarding life sustaining treatments and other medical interventions are known and followed. So again, it outlines specific medical treatment preferences that you want. It applies when you are not able to make those medical decisions. It provides guidance for healthcare professionals and loved ones for, again, what you want to happen. And then what is a medical power of attorney, also known as a healthcare proxy? It designates a specific person to make medical decisions for you when you cannot. So we did talk about medical power attorneys earlier when we talked power attorneys. So in contrast to a living will, a medical power of attorney provides specific. In contrast to a living, in contrast to a living will, in contrast, a living will provides specific instructions about the types of medical treatments you want. Medical power of attorney designates someone to make those decisions for you, right? So often these two documents work best when created together, right? So you have a living will saying, hey, I want this to happen, but then you also designate someone to make those decisions for you with a medical power of attorney, right? Sorry, I got a little bit confused by the wording here. So now that you have that in place, what is the last document that you need part of your estate plan? Again, that HIPAA release, right? We talked about the HIPAA release. What is it? It's written authorization that you give to a covered entity, right? Like a doctor, hospital, health insurance. So you give this HIPAA release to them. It discloses your protected healthcare information to a specific person or entity, right? And so you might not need to sign a separate HIPAA release form provided to your healthcare providers to ensure they share your information with your healthcare agent. So oftentimes, whether it is a hospital, whether it is a long care health facility, maybe it's a behavioral health organization, company, healthcare facility, they may have different HIPAA release forms that you need to sign and give to them, right? So if you are part of a healthcare network, if you have a doctor that you work specifically with, they may have a specific HIPAA form that you need to sign, which is going to be different from other ones, right? There's not a real general HIPAA release. And I would recommend that you work with your doctor, you work with your hospitals, you work with any other facilities that you think you might be a part of. Ask them to give you their HIPAA release form, sign it, submit it to them, and if you ever need to use it, they could pull it up and say, "Oh yes, we know this patient. They filled out this HIPAA release, and it looks like they designated this specific person to, not only help make medical decisions on your behalf, but also review your medical records, right? See the medical information." Okay. Other issues to consider. By the way, we are coming up to the end of this webinar. Let's talk about relationships with informal documentation. This is the one I hear about so often. I'll give you the story. So there was an individual. He was in a 20-year relationship with another person, and then he passed away without a will. And that person who was living with the person who passed away wanted the house that she's been living in with that other person for 20 years. Unfortunately, there was no documentation whatsoever of this person living there, besides, of course, like utility bills, maybe a mailing address. That is not enough. So, without a will in place, the house, which was owned specifically by the person who passed away, there's only one name on the title. That house may get passed down to their next of kin, right? Or their next beneficiary, whoever it might be. Children, most likely. If they don't have children, maybe their next of kin, right? So brothers, sisters, maybe even a cousin. So there was a lot of tension and a lot of stress and anxiety because that person, the person who's been living in for 20 years, there was no formal documentation. They're not married. They don't own anything specifically together. So yeah, that's something you should think about, especially if, again, you're planning for your estate and you want to make someone a part of it. Make sure they're documented in some way on a will, in your trust. Get married, right? If you've been living for 20 years, what's the harm in getting married so that they could have some kind of claim to your assets, especially if you pass away very suddenly without any kind of will or trust or other plans in place. Pets. The other thing is, what do you do about pets? Who's going to take ownership of the pets? You don't want your pets in probate for 10 years, right? Make sure you have the pets that you own designated for someone to take care of. Insurance, right? We talked about insurance, the importance of having insurance. It falls outside of the probate process so that it can help pay for funeral arrangements, as well as help supplement income for your family, especially if you're going through probate, while they're going through that probate process. Long-term care, right? If you don't, this is a whole nother presentation that I do. I'm talking about, is your retirement going to be enough, right? So we talk about your 401ks, IRAs, all these other stocks that you might own, retirement, maybe if you have what do you call it? If you have payments that coming to you, royalties, that kind of thing, is that going to be enough for your long-term care, right? Social Security, all that kind of stuff. Charitable giving. We didn't talk about that here. How do you make sure that your estate gives a certain amount to a charity? Again, part of that will, part of that is a trust if you have it. You want to designate it there. Another thing to consider is any kind of dependents who have special needs, right? Who are you going to designate to take care of them? Any kind of strange spouses and family members. Very often, and I'm sure you've heard of this, where someone passes away and suddenly all of these family members come out of the woodwork making claims that, oh, grandpa said he would give me this vacation home in Hawaii, and that kind of thing, right? So consider those. If you're planning for your estate, hey, who do I know that I made a promise to when I was I'm going to say 5 years old, but when I was really young, and I want to make sure I contact them as well as list them specifically in my estate plan, so that they know that, hey, they're here, they're part of it, but I'm giving you this specific amount, especially if you made a promise to them, right? And then blended families. So blended families are families of many different ages and groups, especially if you have multiple families, right? So if you got married and then got divorced and started a whole other family, lots of different other things to consider, right? Okay. Online account access, so important. I talked about this in another webinar. We talk about sharing online access, especially letting people know where they can access your passwords and usernames, especially if you pass away, especially very suddenly. It is incredibly hard for beneficiaries to get access to your online accounts, especially if it's going through like the probate process, right? Because without having that authority for them to go access your online accounts, whether it's emails, whether it is bank accounts, whether it is online investment accounts, really hard for them to get access to those without the authority from a trust or from a probate judge, right? So make sure you have given those or at least let them know where they could get access to your accounts. Um, okay, I'm not going to dive too deep into taxation. It'll take me forever, but I do want to put it out there, right? It's something that a lot of people don't really think about, but it is definitely out there, and it changes. By the way, it changes every year. The estate taxes, gift taxes, inheritance taxes, these taxes laws change every year. So you always just want to review, see if your estate is subject to these estate taxes, gift taxes, or inheritance taxes. Do your research, check your assets, make sure if it is. Again, for a trust, it could sometimes be outside of these sometimes, but you definitely want to check on that. And then let's talk about some things to remember when you're planning for developing your estate plan. Uh, Consider getting a professional and personalized help, right? Going all the way back to the beginning, you don't need to do this by yourself. You don't need to be alone. There are professionals that do this all the time, and they could give you advice. They've probably seen it all, and so they can look at your situation, figure out what makes sense for you. It might cost something. It might be a one-time cost, right? Set up a will, set up a trust, a one-time cost, and then from then on, especially if they're very good, they could give you help on how to continue to update it, right? But just check it out, especially if there's a lot of individuals willing to talk to you for free about helping you, develop your estate plan. Update your estate plan every 1, 3, or 5 years minimum. By the way, you could update it as many times as you want. Sometimes it can be very expensive, right? So if you have a trust, it may be expensive to update your trust, right? Especially if you have a lot of different assets. You have to get it notarized. You have to, do a lot of different changing. Sometimes if you haven't updated your trust or maybe will in 5, 10 years, you almost have to create a whole new one. And this is because your executors, right? Your executors, people who are going to execute your wishes, they might change, right? You might have had a best friend, but a falling out, and then 10 years later, you want to change your executors. Makes total sense. You might want to do that. Removing, updating, adding beneficiaries, right? Removing, adding assets, right? You buy new property, maybe you sell some property, make sure those are in or out of your estate plan. Again, taxation laws, we talked a little about that. Maybe certain property that you acquired are now subject to taxation laws. Maybe certain financial accounts you have are going to be subject to taxation laws. So that's something you want to plan for. Digital assets, and then of course changing your healthcare wishes, right? Maybe you did not want a certain procedure for you to go through a certain procedure, but in 10 years that procedure has evolved so much that it's much safer, maybe higher level of success, that kind of thing, and you might want to add that as part of your healthcare wishes, right? So again, update your estate plan as often as you can to cover some, if not all, of these different issues. I do want to talk quickly about estate planning scams and fraud, right? So unsolicited calls, emails, sales offers, always be wary of those, especially if you did not go out and initiate. If someone is calling you or they're knocking on your door saying, hey, I could put a will together for you for $100 or $500 or something real cheap, $50 will, I'll put everything together for you. That's probably not a professional you want to trust. Any kind of, again, high pressure sales tactics, promises of high returns or taxation avoidance. This is a big one. Maybe you have a lot of assets, maybe a lot of financial accounts, and you don't want to deal with it. So you hire a professional who's promising, hey, I can get you to avoid all taxes. You want to definitely check that out, right? Do your research, check testimonies, make sure that their claims are legitimate. Fake or unqualified professionals, right? Someone who is probably just going to use a do-it-yourself kit for you, which you could probably do yourself for free or cheaper. Make sure, again, to review those professionals. Excessive fees, right? Someone who is maybe saying, I'll put your will or trust together for free, but then every year they charge you a certain amount, or maybe every time you want to update it, they charge like $500, and they write some kind of exclusivity clause in there saying that it can only be updated by a certain professional. So you want to be aware of that. any kind of complex trust schemes, avoid those, right? Anyone who is trying to create, again, things to avoid taxation or moving assets around a lot, that if it's too complex for you, right, listing out your assets, listing out your beneficiaries, what happens to it all, if it's more than complex than that, then it might be a scam or some kind of fraud. So be aware. Insurance or investment scams disguised as estate planning, that's a big one. Oftentimes, you may get someone coming into your house, knocking on your door, giving you a call, saying that they are a estate planning professional, or I'm certified estate planning professional. There's not really kind of any designation for that, by the way. They're probably trying to sell you insurance or maybe some kind of investment. So be very wary of that, right? If they want you to buy a product instead of actually just creating your will, creating your trust, those are big red flags. Exploitation of vulnerable individuals. This happens a lot as well. And then, of course, fake debt collectors, right? Debt collectors who are making illegitimate claims on your assets. I will say one more thing here. You also want to be aware, be very careful that if a professional is putting your will together for you, you read through that will before signing it, or will trust. Read through it very carefully. I've heard stories where a professional put together someone's will or trust and they wrote themselves into that trust, right? And the beneficiaries could not make other claims otherwise. It says right here that grandpa wanted to leave 10% of his assets to this person that wrote their will, or updated their will, or updated their trust, right? And of course, beneficiaries are not going to read through your trust or will until they see it themselves, or until you pass away. So be very, very careful of that, right? Heard stories of it. Just want to make sure you're protected. Okay. More information if you're concerned, if you want more help, right? If you have concerns about attorney or fiduciary conduct, you could always contact the state California State Bar. There's also the DCA, Department of Consumer Affairs Professional Fiduciaries Bureau, right? That's a link to them. Dispute over fees can be reviewed by the State Bar of California. Elder financial abuse or exploitation, contact Adult Protective Services. There's also a long-term care ombudsman, and there's a link to that. Of course, there's the Bureau of Medical Fraud and Abuse. There's a link there to learn more and how to report it. Any kind of fraudulent activities, you want to contact us, right? California Department of Financial Protection and Innovation, also known as the FBI. And then, of course, the California Attorney General. So you go to their website as well to report any kind of conduct issues, right? Okay. Q&A. If you have any questions, I do have a couple questions that were emailed into me. We have a couple minutes for the live Q&A. Again, as a reminder, please submit your questions through the Zoom's Q&A feature. I'm going to get to as many as I can. First question, is there a disadvantage listing your revocable trust as a beneficiary, for an individual account rather than retitling the account to the trust's name? Thank you. Okay. Is there a disadvantage of listing your revocable trust as a beneficiary for your individual accounts rather than retitling the account to the trust name? I would say the only disadvantage, this is, by the way, this is a very specific question, and I'm going to answer it the best as I can. So what this person is talking about is, hey, let's say I have a house, and instead of taking that house and putting it into a trust, I'm going to go ahead and just change the name on the title to that person that I was going to give the house to anyways. And you could do that, by the way, you could do that. Especially maybe if you're, thinking maybe you got a bad diagnosis and you're planning to leave this world and very, very short notice. You can just retitle a property and give it to someone. There's taxation involved in that as well. There's some fees when you retitle something. So taxes might be the biggest disadvantage because it's essentially a gift. You are gifting someone the title to the house versus moving it into a trust. And then the trust, I'm not saying a trust would avoid the taxes, but there might be different taxes involved. The other thing to consider is, let's say in the instance of a house, by the way, again, very specific here. And you might be referring to other things like an account. But for a house, there is what do you call it? The capital gains on a house. What do you call it? It is the appreciation of the house. When you move it into a trust, or when someone inherits it, there's a tax involved, as well as also transferring it. There might be a certain tax involved. So check on all that. Is there a disadvantage? Not necessarily, except for the fact that when you give someone the title to the house, they could do whatever they want with it, right? Especially if you're living in that house still, they might be able to sell that house from under you because they have their name on the title versus putting it in a trust, especially with instructions that, hey, I don't want this house sold or transferred over until I pass away, right? So that would be the only disadvantage. But very good question. Again, very specific, and I hope I was able to answer it as best as I could. Okay, one more question. I actually had two questions that was submitted to me by email. I don't see anything else that has been submitted. When should I update my will? Again, my own personal recommendation. You can update your will or trust as often as you want. It can be expensive. When you should update your will, I recommend doing it at the end of the year, right? So like around December. That's why we're doing this webinar. It gives you a chance to very oftentimes meet with family, right? You're at the family Christmas party or Thanksgiving party. You want to just talk to everyone. Hey, I'm updating my will. I bought a new car, and I'm going to pass it on. I'm going to give it to you if I pass away, right? Or I sold this property, but then I bought a new property, and I'm going to pass that on to you. I'm going to put it in the trust and designate you as the beneficiary, right? It's a great time to meet new beneficiaries, right? Grandchildren coming in your life that you don't know, and you want to make sure to get their information. Name, social security number, that kind of thing, so that they're in your trust or will. So that kind of thing. It's at the end of the year is usually kind of the best time to do it, in my opinion. But you could update your will or trust whenever you think's best. Last question, and this is one I get a lot. How much does it cost to create a will or trust? The answer is could be very wide ranging. And again, that's mostly because everyone has a different life situation, right? Maybe you have a lot of assets and a lot of financial accounts, and you want to put it in your will or your trust. That might be very expensive because you have to list a lot. It's going to be a lot of paperwork. And also maybe you have a lot of beneficiaries, so you got to hunt them all down to get their information so they get put into your will or trust. So it could be very cheap. Like you could do it online. Some places do it for free. But it may not be as thorough as like professional that you might hire to create a very thorough, all-encompassing trust and will, especially something that's very flexible that you can continue to update, revocable trust. So the prices could be very wide, and I can't really give you a specific number. But again, big proponent of you doing your research, checking out all the resources and making sure that you find the right professional or getting the right information that can help you in your specific case. Okay, that's it for the questions. I do want to say a little bit of housekeeping here. Reminder, this is actually our final financial education webinar. We're going to be transitioning to our fraud and scam awareness webinars. So our next one is in January. It will be protecting yourself from tax scams. And that webinar is going to be at 1 p.m. We usually do our webinars at 12, but because of some feedback, we're going to be changing it to 1. So it's going to be a 1-hour webinar. Again, talking about how to protect yourself from tax scams. Here's a link where you could register for that webinar. Again, these slides will be sent out to you. And with that, I want to say thank you so much for joining the webinar. Thank you for submitting your questions. And I hope you have a great one. Please take care of yourself and each other. Goodbye.